I see you filed some motions just moments ago.
I did, Judge.
Mr. Kelly, I'm taking a look at those to see if they're ones that can be handled
That's fine.
without notice. All right. Ms. Jolette, are you ready to begin the hearing set for today?
I am, Your Honor. I haven't received any other copies of motions of any kind.
Mr. Kelly, you didn't serve the prosecution with copies of your motions?
I apologize, Your Honor. I was unaware of the need for that.
Yeah, they have a right to those motions. They should.
Yes, I thought it was all connected.
Okay. All right.
Do you want me to email them?
Oh, Ms. Gillette, do you want them emailed to you? I don't know if you're going to have time to respond to them if you get them or not.
I won't have time to respond in writing because
Sure.
during trial.
Why don't you go ahead and send them to her, Missy? This isn't the appropriate way to do it, but let's go ahead.
And I emailed a copy of my response to Mr. Kelly, but I also have an extra copy here printed in my office beside the one to mail.
All right, so maybe she can take one down, take it to just exchange them back and forth. Well, no, you're going to email it, right, Missy?
Yes.
Mr. Kelly, do you have your email available to you?
I do.
Okay, you might want to check your email if you haven't received
I
that
will.
response to motion to dismiss.
I'm actually not seeing it, Judge. I see one for the Zoom meeting from Missy, but I have no other emails.
You don't have one for Jill Gillette or Greenwood County Attorney?
No, I do not.
Okay.
I'll just walk one down to him, Judge.
Thank you.
Ms. Gillette.
Judge, you might look again because there was several filed. There was actually maybe 7 filed.
Are you talking to me?
Yeah, the motions.
Let's see. I counted up 1, 2, 3, 4, 5. Discovery for inspection 6. I think I looked at that, but I may have. Yes, I saw that. Let me look at 7 is the one called information notice. No, that's some of those kind of duplicate. The titles duplicate, not the contents. Yes, I did see all of those. Thank you, Missy.
Thank you, Jill. Appreciate that.
Well, no, there's another one I didn't see. That motion to suppress prior conviction. I don't think I saw that. Okay, well, why don't we get started with what we can do today? There's a lot that's been filed here. Some of it we can deal with this morning. Some of it maybe not. We are now on the record in the 13th Judicial District, District Court of Greenwood County, Kansas. Would the parties please announce appearances? Ms. Gillette, you're muted.
May it please the court, the state appears by Jill Gillette, County Attorney.
This is Greg Kelly appearing as the accused.
Thank you, Mr. Kelly. All right, we were set for jury trial tomorrow with the defendant.
From the very start, this hearing feels like a slow-motion disaster. Mr. Kelly floods the court with last-minute handwritten motions, leaving the judge sorting through confusion and delay. It's the hallmark of pro-se chaos, someone trying to play lawyer without grasping the rules. The result? Disorder, frustration, and a legal train wreck unfolding in real time.
Need to be addressed. Count 1 is the unlawful possession of the controlled substance THC and or marijuana after a prior conviction. And that prior conviction is addressed in one of the new motions filed. Count 2 is unlawful possession of drug paraphernalia, being marijuana roaches, which I believe would be considered rolling paper wrapped around marijuana and or THC in a small remainder amount. Count 3, no proof of insurance, which I understand The defendant brought in proof of insurance in a timely manner and the state dismissed count 3. So although it's referred to in the new motions, I don't believe it needs to be, but we'll address that at another time. Count 4, the registration offense. The defendant was pulled over initially for allegedly not having a current tag on his automobile, and the defendant addresses that as well. So with that being why we are here, there was a probable cause affidavit filed August 17th, and it was prepared and sworn to by Greenwood County Sheriff's Deputy Blake Fisher. The defendant had a surety bond that was filed August 18th of 2022. That was August 10th of 2022 and secured by Collins Bell Bonds in the amount of $7,500. We have the September 6th request for trial by jury, handwritten but filed by the defendant.
The charges are minor: possession, paraphernalia, no insurance. But Mr. Kelly turns a simple case into a full-blown constitutional crusade. He's not defending facts. He's battling the system itself, diving headfirst into sovereign citizen logic as if the entire court is his enemy. What should have been routine now feels like a rebellion against reality.
Conflict of interest. I'm being tried by the state, judged by the state, and the state is also the victim. Well, what is your legal argument there, Mr. Kelly?
Well, I don't see how I can get a fair trial when the state has their hand in every aspect of it.
Well, I think I understand what your argument is, but you have to understand all the people within the state of Kansas make up the state. And even though that is true, that we're all citizens of Kansas if we live in Kansas and work in Kansas or work in Kansas, we do have different jobs to do. And Miss Gillette gets her paycheck, I believe, from the county of Greenwood, in that my job is one that gets paid by the state of Kansas as a judge. So Miss Gillette and we don't work with the same people. We don't represent the same people. Her job is to represent and protect. My job is to protect, but it is to protect both the defendant and the state, the citizens who are violated by the law. And I look at the evidence fairly impartially that she has. I look at your side fairly impartially. So no, Ms. Gillette and I are not conflicted in this case at all. The victims of the state of Kansas, some of them don't even know this is going to trial. Probably very few of them do.
Here's where it goes off the rails. Kelly claims the state can't try him because it's both the victim and the prosecutor. A textbook sovereign citizen fantasy twisting the justice system beyond recognition. But the judge doesn't flinch. Calm, precise, and unshaken, he dismantles the nonsense with quiet authority. A man clearly seasoned in handling this brand of courtroom chaos.
The judge himself. And therefore, he bypassed one of my major, a substantial right, which was the right to gather my witnesses before a judge before he proceeded with any other action. And he chose to ignore that responsibility, which is part of his constitutional oath. And so he took it upon himself to use the judicial power, which he did not have privilege to.
So are you saying that he had a duty to bring you to the judge before he completed his investigation and made his arrest?
No, not well, in part, but mainly before I was booked or processed. I needed to see a judge before I was booked and processed.
All right. Ms. Gillette, are you you prepared to respond to that?
Judge, I don't have all the research before me, but when an officer makes an arrest, he is to execute a probable cause affidavit, which is reviewed by the state and then subsequently by the court when the court reviews the sufficiency of the evidence based on the probable cause affidavit that is recorded with the complaint. The probable cause affidavit is not public record. It is part of the judicial file, but it is often under the confidential seal of the court, because it often contains birth dates, addresses, or specific information. In this matter, a probable cause affidavit was executed and was recorded with the court, and the court then records that for future use. So it would say that that is the proper protocol according to the statutes and the law under the state of Kansas, and that the officer in this matter followed his directive of having probable cause to effect arrest.
I object to that, Judge.
Anything else you'd like to say? Go ahead.
It's a known constitutional right that I have the right to go before a judge in order to gather my witnesses and present them before a judge. Having been brought in on a misdemeanor, the fact that it was a misdemeanor, he had no right to arrest or to prosecute, and he took it upon himself to do both. And the support of probable cause that I am privileged to was not a affidavit in support of probable cause. It was an affidavit in support of a complaint, which gave the prosecutor the access to continue from that point, because she had to have an affidavit in order to write up the complaint. The affidavit in support of probable cause has to be signed by a judge. And so therefore to my knowledge, he bypassed that process. And again, causing me due process violation by violating substantial rights. I realize that police officers, law enforcement officers do not take you to the judge, but I specifically demanded that I had that right. And when I voiced that right became in effect. And he chose to ignore it. And therefore
Now watch this. Kelly claims the deputy acted as a judge because he wasn't taken straight to court. A claim with zero legal grounding but deep in sovereign psychology. This isn't about law or logic anymore. It's about belief. The belief that every procedure is a plot and every authority a threat.
That portion of the motion. Counts 3, no affidavit in support of the warrantless search. Again, that affidavit is very clear. It is part of the file that the court takes judicial notice of, so that is denied.
Is that sealed?
That does go through a sealing process, but you can get a copy of that if you haven't already.
He has a copy of the affidavit.
He does have a copy that was supplied when he asked for it originally.
Yes. I have to object because it cannot, in my impression, it cannot be an affidavit in support of probable cause unless it was signed by a judge. It was signed by a notary.
Well, the inactive warrant was signed by the judge based on the probable cause affidavit.
And I never received that. So I would like to.
Well, let's sort through that because Ms. Gillette says you were given that. Let's make sure you know what it looks like since you're representing yourself.
And I would also.
And again, are you certain that you do not want an attorney to represent you, Mr. Kelly?
Judge, I do not. I really do appreciate you taking the time and patience with me. I know that it must be very frustrating for you. And I apologize in advance for that. But I am not comfortable with attorneys.
All right.
I have very little faith in the court system. I apologize.
Nothing to apologize for, sir.
You can sense the judge's empathy here. Kelly admits he doesn't trust attorneys and even apologizes for being difficult. a rare moment of honesty. The judge doesn't mock or scold, she simply listens. It's a quiet clash of frustration and compassion, law meeting raw humanity.
Affidavit was filed August 17th of 2022. And it should say electronically filed and then give you the information about the court case number. And then underneath of that, it should say affidavit, and it begins, I, Deputy Blake Fisher. You don't think you have that document?
I do have that document, Judge.
That is the affidavit. When we refer to affidavit, that's a 3-page document. And the last page says, Deputy Blake Fisher, and it is subscribed and sworn to August 11th, 2022 by Gary Murphy, Notary Public. And then you should also have, typically there is a warrant signed by the judge. Do we have one of those, Ms. Gillette, that you see?
In instances where the person is arrested based on probable cause, the state must file a complaint against the defendant. There isn't an actual warrant because they were already effectuated upon arrest, so they are not re-arrested. Sometimes we issue inactive warrants, but in this matter, because he was already placed in custody, he was not re-arrested. And the case law on that is State versus Goodrow, 506 Pacific 3rd, 918. It's Kansas case number 121,944, decided in 2022.
All right. Well, that's one of those things, even though we're in the same judicial district, the counties do it differently because historically, Butler County does file what they refer to as an inactive warrant after the court has reviewed the affidavit, and then we still sign off on the warrant even though it's labeled inactive, but it shows that the affidavit is approved by the court and supported. But Ms. Gillette, you're saying that Greenwood County does not do that practice. They rely strictly on the probable cause arrests in the affidavit. Is that correct?
Yes, for misdemeanors.
For misdemeanors. Okay. And the case on site is 121 Kansas 944?
Yes.
Okay. And you said that's
21944 is the case number. There isn't a Kansas site yet because it hasn't been published.
okay. Okay. So it's 506 P 3rd?
Pacific 3rd.
And it does. Okay.
And Your Honor, when it comes to misdemeanors, that goes over that in that matter. The defendant has to be brought before a magistrate within an appropriate amount of time, depending upon whether or not they remain still in custody or whether they are released from custody. The procedure under the Kansas law has been followed in this manner. The defendant had a first appearance. His first appearance being on he had technical issues on August 30th and was moved to September 6th of 2022, of which there is a transcript of the first appearance.
All right. So, Mr. Kelly, what you might want to do is take note of that case she cited. What was the name on it?
State v. Goodrow.
Good?
Goodro.
All right. State v. Goodrow, and it's 506 Pacific 3rd. That's the set of books it's in. And 918 is the page where that can be found. So that may answer that question. I think the better practice, I like the practice better that we do in Butler, but I'm not going to say that Greenwood's doing it wrong either. I don't think we are. I'm finding that we aren't, and that
Well, if I may object to that, I would like to object on that ruling.
well, I would suggest, sir, what you do is we rule on these, we pare them down.
Okay.
And if you want to file a motion for rehearing, because the state's probably not liking the way I'm doing this either. I know Ms. Gillette likes to do her research and write her answers out. I'm trying to find a way to
As long as I have that,
some of these volumes of
okay. As
documents.
long as I have that option. Thank you, Judge.
And deputy creating his own exigent reasons. Tell you what I'm going to do. I'm going to order that these be written up in more detail, because these are just too vague. If you'd write up more reasoning for these, and then I'm going to give Miss Gillette time to respond in writing if she wishes, because you've got so many. I'd hope to.
I would appreciate more time. I did not have less than 24 hours to put this portion together. So if I could rewrite it and be more.
I would beg to differ with you there. I think you've had, since this case started in August, to do whatever you wanted to do on it. But
Yes, Judge, correct.
this is going to be so cumbersome, and it's 1:45 and we haven't even gotten but into 4.
This moment is pure gold. The judge methodically dismantles Kelly's pseudo-legal fantasy, citing real case law and proving the arrest was fully lawful. Every objection, every interruption, handled with calm precision. It's a masterclass in professionalism where patience meets delusion head-on, and real justice prevails.
For review.
Okay. Well, and that one I do, that one I think I've already addressed, that under probable cause he didn't have to bring you to the judge, that he did act properly in that one. I'm very confident of that. Okay, well, let's set this over. We're not going to be having a jury trial tomorrow. So, and I'm going to have you limit this to get all of these pared down. I'm going to give you about an hour, Mr. Kelly, to argue everything you want to argue. So make sure you really refine these.
That's fine.
Put
That's
them in
fair.
a way that they make exact sense to the state and to me as to what you're actually saying.
Okay.
And so, Missy, can you give me about an hour? And did we reset? Let's reset this for jury trial June. What's that date? June 13th for a pretrial?
June 12th for pretrial and June 14th for the jury trial.
All right, so I'm going to move your jury trial to June 14th and 15th. Your pretrial will be June 12th. And then I need about an hour before that June 12th date for his motion hearings.
Okay.
And if he files a motion to suppress in the traditional sense, then we will need to, I think I saw something called motion to suppress, but again, I'm not sure that they meet the,
That was,
but you've got to meet the legal definitions for these things. It's not enough to use the legal terms. You have to know what they mean.
I will get help with that.
Okay, and have legal cause.
Thank you, Judge. I appreciate your patience, and I know it's frustrating for you, and it's frustrating for me, but probably not as much as it is for you. And
well, no, I do my job, and whether it's frustrating or not, that's no concern for either one of us.
Judge, if we're having this pre-trial on the 12th of June, what day are we having the
jury trial?
The motion?
Missy hasn't been able to give me that date yet. She will as soon as she finds it.
Do you want to do like April or May?
It makes me no difference. We can do it sooner rather than later. Ms. Gillette, do you have a preference when we do it? But I want all the issues heard at one time. I don't want to do it like we did where we had one motion filed a couple months ago, and then we have a whole bunch of motions filed 5-10 minutes before we're supposed to start today.
I agree, Judge.
Okay.
Thank you for that extra time.
All right. So whatever day you have, Missy, about an hour
Okay.
at the most.
At April 7th, we could start at 9 and we could actually go till 11 if it took longer.
Okay, but I don't want to encourage it to go longer. I want everybody to get in there and be succinct. So, Missy, what day of the week is that?
It's a Friday.
Okay, Friday, April 7 at 9 to 11, you said?
Yes.
And that was on the motion hearing. And then the jury pre-trial was on January or June 14th and 15th?
The pre-trial is June 12th. That's what we had yesterday.
Okay.
And then the jury trial itself, where you're here with live witnesses, we're picking witnesses, they're deciding your case, will be June 14th and 15th.
Okay.
And I just caution you, Mr. Kelly, because you told me you don't trust lawyers Don't go out and get advice from non-lawyers because, first of all, it's illegal to practice law without a license.
And finally, the judge delivers a powerful warning: don't take legal advice from non-lawyers. In other words, don't let internet experts wreck your life. It's not about marijuana anymore. It's about how self-representation turns into self-destruction. The judge ends with pure composure. No anger, no ego, just firm authority and grace, proving that real power in a courtroom comes from control, not volume.